So this is our discussion opener question. So feel free to answer as your thoughts come to you. What is the most important thing to keep in mind when creating, implementing, and modifying the settlement plan? Yeah, we'll ask you a different question to help you think a little bit further about this question, because I think what was shared already is really important to keep the needs of the refugees in mind. That would be something central to think about whenever you're doing anything with the settlement plan, whether you're first creating it, whether you have to make changes to it, or whether you're actually acting out the things that you've put in the settlement plan. So what should sponsors think about to include in the settlement plan when something changes? Maybe give us some examples of something that might occur which would be a reason to update or change the settlement plan. Yeah, absolutely. When there's somebody new, absolutely, and you're right. They should be included, whether they're presumed missing, or even if people believe that they have died, they should still be included on the form. But once they're found, if they have an awareness of where they are now, you should update the settlement plan, absolutely, and let IRCC know. Yeah. What's another example of when you would need to update the settlement plan? Yeah, yeah, when a status changes. Any changes to that family composition are really important because sometimes at the time of application, the family may have teenagers, young people in their family who grow up and become adults while they're waiting for their application to be approved. And if one of those children gets married, or maybe they were engaged when the application was submitted, and then they get married, that has implications for the settlement plan and application. So IRCC does need to know, and that would make a difference for the settlement plan as well. Yeah. Let's think about on the sponsor side. Maybe not changes about the refugees, but what about changes for the sponsors? What would make it a necessity to update the settlement plan in relation to the sponsors? Something that happens where a sponsor has agreed to provide accommodations. And let's say you're notified that the refugees are scheduled to arrive in Canada, but you found out that week that the home of the person who was going to be providing the accommodation has burnt down. That would be a tragic example, but it happens. And so updating the settlement plan in that circumstance is necessary as well, to be able to also have a backup plan for things like that in your settlement plan so that people know what they're going to do if something happens similar to that. And so, yeah, those are really good examples of why you should update the settlement plan. So the idea that the settlement plan is a living document, that term simply means that it isn't static, a one-time, stone copy. It means that you're going to make changes to it and update it through time as things change. And so that's really important. And in particular, we talked about the idea of children who grow up and end up getting married before the approval to come to Canada is made. When that happens, those children are no longer considered to be the dependents of that principal applicant. So they will need their own application separate and apart from the principal applicant, even if they had originally been added to the application before they were 18 years old. Or even if a child gets married, with their parents' approval, married at 17 or 18 years old. as soon as they become married, they are no longer considered part of that family unit of the principal applicant, and they will need a completely separate application, which includes themselves and their spouse. And they will need to meet the definition of a refugee as well in that case. But the application can be linked to the principal applicant, the original principal applicant's application as well. And of course, with a separate application means that there will be a completely separate calculation done for the cost of sponsorship as well. Because when a child is included with their parent's application, when you submit the application, it would be considered, if it was two parents and two children, that would be considered a family of four. Well, now it's not a family of four, it's a family of three. And in fact, you have to calculate for two others, right? The child who got married and their spouse who you're going to sponsor. And you have to be able to prove that you have the financial capacity to sponsor 5 people now. So those are some things to keep into consideration when changes happen. So thank you so much for joining into the discussion. I will go into my review now of Module 5. When it comes to the settlement plan forms, this module doesn't go into details. You'll learn more about those specific forms in the next module. However, it's important to understand the differences between the forms for each group type. And so remember, this review is for Module 5, last week's reading materials that you have gone into. So if you've already started Module 6, you might have learned already about the settlement plan forms. So when it comes to groups of 5 and community sponsor groups, they have a combined undertaking and settlement plan form. And they are always required to submit a new undertaking and settlement plan form for each sponsorship they wish to commit to. And they must always provide proof of funds documentation for each sponsorship as well. Now, when it comes to settlement plans for sponsorship agreement holders, however, it's a little bit more complex. And we'll discuss that right now. So sponsorship agreement holders in the past year or two have undergone some changes to their agreement with the Government of Canada. And now the Government of Canada is implementing a process of reassessment to make sure that the sponsorship agreement holders continue to maintain that level of financial capacity to be able to sponsor refugees. And as part of that, they are placed into different risk management plans. And with those risk management plans, there are different requirements. And so when it comes to Risk Management Plan A, these SAWs have a separate settlement plan form to complete that is not part of their undertaking to sponsor form. So the separate settlement plan is called IMM 5440. And although they use the same undertaking to sponsor form as the other SAWs do, the IMM 5373 form, as soon as they check mark that they are from Risk Management Plan A, it directs them to complete this separate settlement plan form. And this is because they're not required to submit that form along with the application. However, IRCC does require that the SAW, their constituent group, and co-sponsors do need to complete and sign both of these forms, whether or not they're exempt from submitting the settlement plan to ROCCO. And that settlement plan can be requested by ROCCO at any time, which is why it does need to be completed. It's just meant to be kept on file at the SAW in the event that ROCCO does request it. Now, SAWs who are following Risk Management Plan B, they have a combined undertaking and settlement plan form that includes the settlement needs checklist. And because these SAWs are required to submit this undertaking and settlement plan form with each sponsorship application that they submit to IRCC, when they check mark that they are following Plan B, that settlement needs checklist will become revealed within that form. When it comes to SAWs following Plan C, they also have a combined undertaking and settlement plan form that needs to be completed. And in addition to its submission to IRCC with each application, the SAWs under Risk Management Plan C are also required to provide proof of funds documentation with each application they submit as well. And so their combined undertaking form reveals that settlement needs checklist within the form as soon as they check mark that they are following Risk Plan C, and they must show proof of funds documentation in addition to that settlement plan. So now let's take a look at decision making within each sponsorship group type. So all members of the group of 5 are considered by IRCC to be jointly and severally or solidarily liable. And as such, each signing party to the sponsorship must be well informed and engaged in the decision making and the sponsorship process. The group of 5 may decide to engage in multiple sponsorships together as a group, but they must ensure that they have sufficient funds for each sponsorship, especially if both sponsorship cases were to arrive at the same time. And as for settlement assistance and decision making, it is carried out collectively by the signatories to the undertaking, and decisions are encouraged to be made with the sponsored refugees' involvement. A group of 5 does not have co-sponsors. However, they can add as many signatory parties to the undertaking, so persons who sign the undertaking form. They can add as many people as they choose, meaning they are not limited to just including 5 people, but as a minimum, they have to have 5 people signing that undertaking form. When thinking about decision making within the sponsorship agreement holder group, it's important to understand that SAW organizations function differently depending on how they are structured. SAWs may operate locally or regionally or nationally. These terms are used within the sponsorship agreement holders community and not necessarily by IRCC, although IRCC does know if a particular SAW has the human resources and capacity to sponsor in various locations across Canada. An organization would not be approved for sponsorship in a location outside their geographical area if they cannot demonstrate that they have the sufficient funds in place, known as their financial capacity, and that they have a sufficient number of people living in that location, such as a constituent group or co-sponsors, to manage the settlement responsibilities. In the next few slides, we'll take a look at decision-making within each of the different types of operational structures that SAW organizations may have. So there are several different ways that a SAW can choose to operate and set up decision-making. In this type of SAW structure, all aspects of the sponsorship's administrative tasks and settlement responsibilities that are carried out are done directly by the SAW organization themselves, meaning the SAW conducts its own fundraising and manages the financial disbursements and has a team of people to assist with settlement activities. This is generally how a local SAW operates, where decision-making is primarily between the SAW organization and the sponsored refugees directly. So in this type of SAW structure, the SAW may delegate its responsibilities to a constituent group, but oversight and ultimate responsibility lies with the organization that signed the SAW agreement with the Government of Canada. A constituent group typically belongs to the SAW organization's business model or structure. For example, a faith-based national denomination, such as the United Church in Canada, has several churches who are affiliated with them through a membership. These churches have an accountability link to that national denomination head office, which holds the SAW agreement for the denomination. Another example is a corporate organization that has regional offices across Canada, which engage in refugee sponsorship and have an accountability link to the head office, which holds the SAW agreement for the organization. Constituent groups may be delegated to provide funds and settlement support, or will work in collaboration with the SAW to provide funds and settlement team members. A SAW may have multiple constituent groups, and a particular constituent group may have more than one sponsorship that they are responsible for. CGs should not act independently of the SAW when a decision regarding settlement supports needs to be made. Decision making is carried out with the SAW and with the sponsored refugees' involvement. The SAW is ultimately responsible even if the CG has signed the undertaking document. In this third type of structure, the SAW just works with individual co-sponsors who are related to the refugees being sponsored and who will look after the settlement activities. And in some cases, they will also provide the sponsorship funds. They may also work with co-sponsoring organizations, such as a cultural association, and they may choose to also contribute to the funding or volunteer support of those sponsorship activities. When working with co-sponsor individuals or organizations, the SAW may determine to just handle the application submissions, but it is actually legally obligated to oversee that the settlement activities and disbursement of funds is being carried out by their co-sponsors. Co-sponsors should not act independently of the SAW when a decision regarding settlement supports or assistance needs to be made. Decision making is carried out with the SAW and with the refugees' involvement. The SAW is ultimately responsible even if the co-sponsor has signed the undertaking document. And lastly, some SAWs decide to delegate settlement responsibilities to a combination of both CGs and co-sponsors who are working together. In this first example, the constituent group is working directly with a co-sponsoring organization who is providing the funds for the sponsorship, but the CG and co-sponsor organization are jointly providing people for the settlement activities. In this second example, the constituent group has two sponsorships submitted. For one of them, the funds are being provided by the co-sponsor family members, and the settlement activity responsibility is shared. But for the other sponsorship case, the CG is providing the funds, and the SAW and CG are working together to provide volunteers to look after the settlement responsibilities. Regardless of delegating responsibilities to a CG or a co-sponsor, the SAW is ultimately responsible for the sponsorship. So they should be involved in all matters of decision-making and have oversight of all settlement activities. The SAW should also be in direct contact with the refugees to ensure they are receiving the support and assistance they're entitled to and are involved in the decision-making as well. When it comes to community sponsor organizations, they may structure themselves similarly to a SAW who only works with co-sponsors. However, similarly, regardless of delegating settlement responsibilities or full financial contributions to a co-sponsor, the community sponsor organization is ultimately liable for the sponsorships it undertakes. Therefore, they should always be involved in the decision-making, even if they are not actively involved in the day-to-day settlement activities or directly providing settlement funds to the arrived refugees. They should be prepared to do so, however, if that settlement funding is not provided ultimately by the co-sponsoring individuals. When we think about detailed settlement planning, to begin with, after reading this module, you should realize that settlement planning is a key part of the process, and you should expect that it will take time because you need to organize your team to meet and discuss several things, such as specific needs of each family member of the refugee and the human resources. When it comes to human resources, the number of people who can commit to assisting with settlement responsibilities. So who is part of the settlement team and who is their backup person? And the financial requirements and resources. How much will it cost, and where is the money for the sponsorship going to come from? And so, what is the backup plan for when something goes wrong, something changes, or something unexpected happens? What about when the refugees decide to move away from the intended community of settlement? That is known as secondary migration. And what if there are unexpected medical costs or if a death occurs? So, when preparing your case specific detailed settlement plan, you're going to plan ahead of time for everything that has to be done or taken into consideration. Who will be responsible and what the backup plan is if anything goes wrong. So, before you dive right into the settlement planning, it's a good idea to first take a look at what you will be responsible for. Begin by taking a look at the settlement plan checklist of responsibilities that are outlined in the undertaking forms. And then become familiar with the post-arrival requirements document. And to learn about your financial responsibilities, you will need to pay attention to the Appendix A of the appropriate instruction guide for a SAW, a community sponsor, or group of 5, depending on which group you belong to. And that way you can gain an understanding of what you will need to take into account. You will also need to know the relevant details for the persons being sponsored. Speak to the refugees to learn about each family member being sponsored so you can address their individual needs. So, for example, how many people will be resettled and how old are they? What do they hope for and what will they need when they come to Canada? For example, do they want to go to school or do they hope to get a job right away? Are there any school-aged children? Is anyone pregnant or getting married? Have they encountered any trauma or injuries that will need to be considered? A good settlement plan is well documented. So include everything that has to be done or is related to meeting settlement needs. This is very important so IRCC knows that you have thought of every possibility and that you're well prepared. I suggest that you may want to start with the following general categories, such as housing and furnishings, as well as medical, dental, clothing and food, safety and security, cultural and social, employment and education, recreation and childcare, ID cards and official documentation, as well as banking and budgeting. Within each category, you want to decide among the sponsorship group who will take the lead for each of the categories and assign additional team members who will assist them and include everyone's contact information. Then begin to identify what is needed, how the list item under the category relates to each individual. You may also want to assign a time period for when each item will need to be done and who on the team will be assigned to each listed task. When that is finished, think about what could go wrong and provide a backup solution to follow for ensuring that the settlement needs are still going to be met. And plan to do this kind of documenting for each category and assign a different person to take the lead and always make sure they have at least one other person to assist them or to act as a backup person if they get sick or are unavailable. It's important to name everyone who will be involved in assisting as much as possible. When volunteers change, make sure to update the settlement plan as well. And make sure you know which of the persons in the family has to apply for and receive certain ID cards or official documents. In particular, when it comes to the permanent resident cards, when the family arrives in Canada, you have to update the address information for each family member, not just the principal applicant. Otherwise, some family members will receive their cards and some of them will not. And again, think of all potential problems beforehand, the things that could go wrong, and find out how to resolve them. Document relevant phone numbers and office locations for getting assistance with government services as well. Settlement agencies will become very helpful in these situations. So a big part of settlement planning is calculating the cost of sponsorship and for the group to understand how much money they are legally liable to provide as financial support for the refugees at the time of arrival. So at the time of application, Group of Five and community sponsor groups will be evaluated on their financial capacity to ensure that in general they can meet the cost of sponsorship. And this is actually applicable now to SAWs who are following Plan C as well. And this is why the sponsorship cost tables are used when you're preparing the application for sponsorship. Now, the assessment of constituent groups and co-sponsors is actually done by the sponsorship agreement holders, and that is because sponsorship agreement holders are ultimately responsible for determining the financial risk. At the time of arrival, sponsorship groups are required to use the prevailing RAP rates for calculating their legal liability amounts. And the prevailing RAP rates are actually different than the amounts you would have calculated or come up with on your application. In fact, in most cases, the RAP rates end up being a higher amount than what the sponsorship cost table amounts are. And this legal liability at the time of arrival, being based on the prevailing RAP rates, applies to all sponsorship group types, Groups of Five, community sponsors, as well as SAWs, their CGs, and co-sponsors. You'll learn more about RAP rates and calculating the legal liability amounts for cost of sponsorship in the upcoming modules. Generally speaking, your role as sponsors is to provide both financial and non-financial settlement support to the refugees that you've sponsored for the first 12 months after the date of arrival. And this includes startup costs and monthly amounts. These amounts are based on the minimum RAP financial support amounts outlined in the specific provincial RAP rate tables and the startup cost tables. These tables and an online calculation tool are available on the rstp.ca website under the Responsibilities tab. Now, sponsors are expected to read through the financial guidelines for the applicable guide to the sponsor based on your sponsorship type. So we've got the guide for the SAWs, the Groups of Five, and the community sponsors. And sponsors are also expected to refer to the new post-arrival requirements document for guidance on how RAP rate policies are to be interpreted. When sponsoring refugees, sponsorship groups will not profit financially, and they will not accept funds from the refugees for any of the situations that I'm about to list for you, either before or after the refugees arrive in Canada. So they must not accept funds from the refugees as a payment for submitting a sponsorship or as a prepayment or repayment for lodging, care, and settlement assistance, or as a deposit to guarantee the refugees will stay with the sponsors for 1 year after they arrive. And they should not charge an administrative fee to the refugees. And sponsoring groups will not act as paid representatives. When they represent or they are named as the representative in a use of representative form, the option that needs to be selected is that they are an unpaid representative. And sponsoring groups will not require that refugees, their relatives or friends, must use a paid representative for the purpose of submitting their application. And they are not responsible for covering the cost of the refugee's immigration loan or any debt that a refugee incurs in Canada, unless, of course, you have co-signed loans with the refugee. Now, when it comes to defining a family member, IRCC's definition refers to those who are in the immediate family and not including the extended family. And it's important when structuring applications and for estimating how much money is required for the application to know the family size. So IRCC's definition is different from the definition of a family that we use on an everyday basis. So when I speak of my family, I speak of my parents and my children, my aunts and uncles, cousins, siblings, grandparents. But that is not IRCC's definition of a family. IRCC defines a family as married or common law partners, unmarried dependent children who are under 22 years old, and dependent children of those dependent unmarried children who are under 22. Now, there is an exception for the age of 22 rule for that child over the age of 22 related to physical or mental conditions that they had before they turned 22 that makes them dependent on their parents as a result of that medical condition. If you have somebody, such as a sibling, an uncle, an aunt, or a grandparent that does not fit this definition of a family, they need to have a separate application package. And the same thing goes for children that are 22 and older. They also need a separate application package, and they cannot be included on the same application as the rest of the family. They can, however, link those applications together. So, qualifying dependents, who should be included on the principal applicants forms? So, a qualifying dependent is anyone who meets the definition of a family member we just spoke about. And so the principal applicant, of course, will need to be included on the application, as well as their spouse or common law partner, and children under the age of 22. And you should include those dependents, even if they are presumed missing or they are presumed to have died. On the application, there is the term accompanied and non-accompanied. So you must identify each of the dependents as whether they will be traveling to Canada at the same time as the principal applicant. Those would be known as accompanied dependents. And for those who will not travel at the same time as the PA, they are known as non-accompanied. So those dependents who will never come to Canada, for example, if the principal applicant has children from a previous marriage, they also must be included with the application, even if they will never be resettled to Canada with the PA. And you must, as we mentioned, include those who are presumed missing or deceased. And be sure to include all required family members on the application. Omitting any family members, it does have consequences. It would call into question the credibility of the principal applicant if they were to omit including any family members. So there are several factors which will impact the cost of sponsorship. For example, the family size and composition. Family size, again, refers to the number of people in the family who will accompany the principal applicant. The composition of the family refers to the age and stage of life situations. So, for example, school-age children who are under 18, as well as dependents who are between 18 and 21, if someone is a senior citizen, if someone is married or single, and whether or not they will be coming under the one-year window opportunity provision, or whether they will be living with the signatories to the undertaking. It's for these reasons that the specific needs of each individual within the family also needs to be considered, because it will impact the level of support required. And you should anticipate and update the settlement plan when a specific need is identified. So you need to consider specific things such as disabilities or medical conditions, pregnancies, persons who are missing or deceased, marriages, births or adoptions, and of course, secondary migration, which refers to the arrived newcomers moving away from the intended community of settlement. When it comes to the financial assessments for groups of 5 and community sponsors who have individual contributors. So each sponsorship type, whether groups of 5, community sponsor, or SAW, they must ensure that they have sufficient funds in place for the cost of sponsorship at the time of arrival. You learned in Chapter 1 of this module that the SAW is ultimately responsible for any sponsorship submitted under their agreement. And as such, each SAW should have a process in place to do a financial assessment of any CG or co-sponsors who are contributing funds for the sponsorship. When it comes to community sponsors, the same is true. They are ultimately responsible for any sponsorships they submit as an organization, even if they work with co-sponsors who agree to fully fund the cost of settlement. When it comes to community sponsor groups and groups of 5, each person who's contributing funds from their personal income will undergo a financial assessment by IRCC. The financial assessment uses a simple formula to determine if the financial contributor has sufficient surplus funds. So let's take a look at that formula. IRCC starts with the contributor's gross income minus the cost of living for their family, that contributor's family in Canada, minus any other sponsorship commitments they may have. The amount that is remaining after that calculation is the amount that actually can be contributed. So ultimately, sponsors need to be able to prove the source of the settlement funds they are providing using official documents. Because IRCC wants to know that the funds did not come from the refugees themselves. So next, IRCC will assess whether the group as a whole has sufficient funds for the cost of sponsorship. In the next few slides, we'll take a closer look at how IRCC assesses a group of 5 or community sponsor. And now this also includes SAWS following Risk Management Plan C that have any individual financial contributors. So the contributing sponsor's notice of assessment from Canada Revenue Agency is the best document to use to prove your income. So make a copy to submit. Do not send the original document. And IRCC will be checking for the total gross income on this line here. In this example, we have a single individual who wants to contribute to the sponsorship. So let's calculate what the dollar amount is that they can contribute. So under this line, the total amount shows as $13,030. This will be their gross income amount. Next, we'll see how much money this particular sponsor needs for their own living costs. So IRCC is going to refer to the sponsorship cost tables for this assessment. So in this example, we'll use the amount for a single individual who doesn't have children. The amount is $16,500. So this will be the cost of living amount that IRCC has averaged that a single individual sponsor living in Canada requires annually to meet their own basic needs. Now let's put these figures into the formula that IRCC uses. So how much can this individual sponsor contribute? Well, the notice of assessment amount on line 15,000 was $13,030. The sponsorship cost table amount for this single individual was $16,500, minus any other sponsorships that they may have agreed to provide funds for. In this case, there are no other previous commitments. However, we can see that this individual cannot contribute funds to the sponsorship because they already have a shortfall of $3,470 to meet their own cost of living needs. So in order to be approved as a financial contributor, this individual would have to earn significantly more than the $13,030 that they earn. Now let's take a look at a financial contributor who's married with no children. They have a family size of 2. And let's say their income is $38,053. Since this couple has no children, then the sponsorship cost table's amount for this sponsor's family size would be $24,800. In this case, the couple has already committed $10,000 to another G5 or family class sponsorship. And after calculations, it shows that they would have $3,253 left over to contribute to a sponsorship after their own family's financial needs are met. It's important to note that a spouse's income is not considered in this equation unless that spouse is a party to the sponsorship. So that spouse has also signed the undertaking. And this gets complicated, however, because each of them will be assessed individually as supporting the same family size. Now, RSTP has raised this as a concern to IRCC, but my recommendation is to include a letter of explanation to IRCC to indicate which signatories are a married couple and are being assessed based on the same family size, yet have two incomes to support that family. It may not make a difference in how they assess each individual, but at least it's making IRCC aware that there is a consideration to be made in such situations. And when it comes to the financial support, there are some deductions that may be applied to reduce the cost of sponsorship. Personal assets deductions at the time of arrival, such as funds they brought with them to Canada, or if the newcomers receive money from selling vehicles or property. There are also household income deductions through employment or qualifying federal benefits that they may receive. But please be mindful that the Canada Child Care benefits cannot be used to reduce the cost of sponsorship. Donations, for example, gifts in kind for housing, clothing, furniture, or basic needs. These can be used to make a reduction in the cost of sponsorship. And when it comes to personal assets, the arrived refugees may have money or assets which they intend to sell at the time of arrival. Where possible, newcomers can be provided with opportunities for self-support. When the sponsored person voluntarily discloses their assets, the sponsors can determine if the personal assets amount qualifies for a reduction in the settlement support. RSTP has a document available for download from the website, which can help sponsors and newcomers with making a declaration of personal assets. When it comes to household income deductions, sponsored persons can earn up to 50% of their net settlement support entitlement before any reductions to settlement support can be applied. So, for example, if sponsors are providing $1,000 per month, the newcomer can earn up to $1,500 net income before the sponsors can reduce the cost of sponsorship dollar for dollar. Dependent children's part-time income when they are enrolled in school cannot be used as part of the household income deductions. Newcomer refugees may become financially self-sufficient during the sponsorship year of settlement. However, sponsors must still provide non-financial settlement assistance until the end of the sponsorship period and must be prepared to resume financial support if refugees are no longer financially self-sufficient during the sponsorship period. A note about one-year window support. When signing the undertaking document, you're agreeing to provide financial support not only for the principal applicant, but also for any dependents that come to Canada with them, as well as any non-accompanied family members that arrive under the one-year window of opportunity. And they may not arrive until a few years after the settlement year is completed for the principal applicant. However, you are still responsible for ensuring that they receive what they are entitled to. When it comes to in-kind or donated items, while the cost of sponsorship may be offset when in-kind items are donated, the cost of sponsorship cannot be fully reduced by donations. The sponsorship household shall receive a baseline amount based on the minimum wrap rates and any allowable in-kind deduction percentages. So a note to groups of 5 and community sponsorship groups. Upon arrival, the allowable percentages for in-kind deductions can be found on the RSTP's minimum financial support calculator. When it comes to cultural awareness, sponsors should educate themselves regarding the cultural differences between themselves and the persons whom they are sponsoring. So what gestures, symbols, or mannerisms do our two cultures have that are different? Are there certain foods, religious practices, animal reverences to be aware of? And are there any fears of domesticated animals that I need to be aware of? Is there a cultural center where I can get more information? Sponsors should also be mindful of the inherent power imbalance that exists simply because the newcomers are unfamiliar with living in Canada and because their financial needs are being met by their sponsors. There are some things that contribute to this power imbalance and ways to lessen the impact of the power imbalance. So power imbalance is heightened when the sponsors make decisions for the newcomers and when they assume a newcomer is incapable and when they choose to manage the newcomer's finances. And when sponsors drive them everywhere, then power imbalance is heightened. Power imbalance is reduced when the newcomer has autonomy, meaning they have the freedom to make their own choices and they have independence to do things for themselves when they want to. And when they have the ability to manage their own finances on their own. And they have the freedom to travel on their own where they want to, when they want to. And that they have community connections, so friendships, relationships in Canada that are apart from their sponsors. So that is the end of the presentation. Just a quick reminder of our important dates. We have August 11th coming up. That is the next deadline where modules 5 through 8 need to be completed and the quizzes submitted. And August 13th, we will review quizzes 5 through 8. The 18th is when the final exam is due, and we will review the final exam on the 20th of August. If at any point in time you need some help, do feel free to email me at etraining@rstp.ca Monday to Friday, and I will generally respond between 9 a.m. and 5 p.m. Eastern Time. You can also contact the RSTP helpline Mondays through Fridays, 9 a.m. to 7 p.m. Eastern Time at the toll-free 1-800 number that is showing here. That is the end of our video chat session for today then. Thank you so much for joining, and I wish you the best of luck on completing Module 6 this week, and we'll be starting Module 7 next week. Thanks so much. Take care.